That's Commissioner Burke, 1876. Yeah. Equestrian. We're good so far. Yes.
Okay, we're good to go.
Recording has been stopped and restarted.
Thank you. We'll start with the executive session consent calendar, and it's on agenda item 54, Darby Ayers flood. Anybody need to make a statement? Seeing none. Vice Chair Fiskum, do you have a motion?
Mr. Chair, I do. I hereby move that the commission approve the consent calendar for the executive session dated May 10, 2024.
Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke. In the
Go
meantime,
ahead.
Commissioner Thompson.
Aye.
Commissioner Fiskum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Chair Lindsay.
Aye.
Burke. Okay, motion passed 7-0.
Thank you.
Go outside and see if I can get a hold of Commissioner.
Okay. Commissioners, we're now excusing Dan Gilbert, our legal counsel from the Department of Justice. Thank you.
And do we have We're waiting for her to rejoin.
And we're waiting for Emily Mattizar, sorry. Emily Mattizar to join us. As agenda, and we'll first address agenda item 55, which is on Attorney General Ellen Rosenblum. Just as a reminder, the reason why we're having Dan Gilbert leave is because obviously he's an employee of Attorney General Rosenblum, and so we've hired outside counsel to assist us with this matter, so there's no conflict there, and that's Miss Emily Mattizar.
We're just waiting for her.
Sure.
That's a question while we're waiting.
Yeah.
How do we choose outside counsel for these? Like, how does that process work?
With difficulty. We got a list. We have the independent authority. Once we get DOJ's approval to hire outside counsel, we have authority to hire whoever. We got recommendations from Richard Lane at the governor's office. The first person obviously had to avoid anyone who has a case before us. First person had a conflict, but Emily at Beery Elsener had represented us as special counsel in a prior case. And they passed the conflict waiver problem.
Okay.
We also got recommendations from Dask Risk as well. He's not jumped back on. We do have the next respondent. I don't know if we want to bring him back in and do that, however you feel. A sticky situation, I apologize.
No, that's fine. Let's give it a couple minutes here. Does someone have her phone number?
Yeah, we,
You already done that. If you've already done it, that's fine. Let's give her a couple minutes here. We could move on, but we would want to have Dan back in for that.
Dan doing ping pong.
He's back in here for life.
Maybe we ought to have him do that just because it's fun to have attorneys do ping pong.
It's hazing.
Needs
Pardon me, Ms. Chang,
exercise.
I apologize for my comment.
I think if there's any reason why Emily could not join us on these other matters.
She has not seen the rest because she is only hired for the one. I think the consent, we could have probably left her in for that. But yeah.
reaching out to her, trying to call her as well.
Sure.
Any luck with reaching Commissioner Burke?
Commissioner Burke is on the phone. He's just struggling to unmute, so I think we've resolved it. Commissioner Burke, are you able to unmute yourself?
Yes, I think I can speak now.
There you go. We got you.
Yep, thank you.
That is a massive water bottle size. That you will not run out of water today.
Yeah, I drink multiple of it actually. So.
That's pretty awesome.
Waiting for Emily to join.
We'll give it 2 more minutes. So check your text, check your email. If she's not on in a couple minutes, we'll just proceed with 56.
Not her. But Ruth said she got a hold of, was able to reach her and she should be rejoining now, so.
Okay. Dave, you proud that I wore a tie today?
You can still
Okay.
tie it. That's good.
Emily
I
is,
can hardly tie my tie anymore. I don't know how.
Emily is
You
ready.
just leave them tied and.
Hello, Miss Mattisar. Nice to meet you.
Hello,
Welcome.
thank you. Sorry, had some
That's
technical
fine.
difficulties.
Good to, we're pleasure to have you with us today. All right, commissioners, we are on agenda item 55. And Miss Rosenblum is not joining us today. And let's see here. An investigator is our executive director. Go
Sorry.
ahead.
Thank you, Chair, Commissioners. For the record, Susan Myers. This matter was originally assigned to Hillary, but as she had left us, I put it back. As you pointed out, our DOJ counsel is conflicted. Emily Matazar is here to answer any questions you might have, and she did review and the report that's in your meeting books. So the case before you involves Attorney General Ellen Rosenblum. Robert Parker's complaint in this case is that she had a conflict of interest with respect to his matters that are before DOJ and or his claims against the state. Because her husband owns Willamette Week, and against which Robert Parker says he could file a defamation claim. The report in your meeting books provides a lot of the background as to what happened with Mr. Parker from 1987 to the present. So I'm not going to summarize it here. The immediate matter was that in February, in response to a request from Senator Manning, Task Risk Manager Shelley Hoffman prepared a letter summarizing and evaluating Robert Parker's claims against the state. In preparing this letter, Shelley Hoffman met with DOJ attorneys to find out what was the status of his claims and his cases, so that she could prepare her letter. She also then, when she was preparing her letter, had it reviewed by Task Risk Management's DOJ counsel, Herb Lovejoy. Commission staff, in conducting this preliminary review, confirmed with Ms. Hoffman, with Mark Abrams, the DOJ appellate attorney, with Mr. Lovejoy, that in all of the meetings and consultations, the Attorney General herself was never consulted, did not provide any input or direction relating to preparation of Ms. Hoffman's letter. The complaint also does not indicate or identify any specific actions or decisions made by Attorney General Rosenblum, nor does it confirm that there is any active defamation claim. In fact, Robert Parker provided a 2-year-old notice that he claims he sent to Willamette Week, complaining about statements that were made almost 30 years ago. Ms. Rosenblum, I did get a telephone message from her yesterday saying that she checked with her husband checked with a partner, that they don't have any record of having received it. In any event, I'm not an expert on defamation claims, but it does appear that Mr. Parker's any potential defamation claim, 1, has not been filed, and 2, would be outside the statute of limitations. Based on all of the information, it does not appear that there is a substantial objective basis to believe that Attorney General Rosenblum had a conflict of interest or took any action that would raise a conflict for her in this matter. Therefore, the recommendation is that this matter be dismissed.
Thank you. Commissioners, any questions that you might have for Executive Director Myers? Commissioner Thompson.
Just to clarify, there's no active case. This is not part of any ongoing litigation.
He has two cases one against the Board of Bar Governors and one against, it's a little vague whether it's against DOJ or a state that was, at the time of the letter, was still in the appellate court. The court ruled the same day the letter was issued and said, the case isn't valid at this point because, you know, he accepted a settlement and it got resolved, and then he can't reactivate his claims, is what the court said.
Thank you.
Any other questions? Ms. Matazar, do you have anything to add or anything that you'd like to share with us just in case or before we make a decision?
Nope, I'm happy to answer questions if people have them for me, but I have nothing specific
Okay.
to add.
All right, that said, do we have a motion from any of the commissioners? Anybody?
Mr. Chair, I'll be happy to make a motion. Just a quick preamble. I just wanted to, from the standpoint of having read the documents, thank our staff for its good work on this matter, as well as thank the Attorney General for their seriousness and the tone, character, and content of her response, I think, was right on point to the issue. And I am aware in the past of issues related to the Attorney General and Willamette Week that I know about, but no conflict there for me. So with that compliment, I will make this motion, Mr. Chair. I hereby move the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Ellen Rosenblum has violated provisions in the government ethics law or warrant further review, and that this complaint be dismissed.
Thank you, commissioners. We have a motion in front of us. Any other motions? Seeing none, any comments on the motion before us? Seeing none, we'll call for the vote.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion pass 8-0.
Thank you. Ms. Matazar, thank you for joining us today, and we're going to invite Dan Gilbert back in. Thank you.
And
Thank
I just
you.
wanted to say thank you again, Emily. It was very helpful the way you stepped up.
Oh, thank you.
Yep. Thank you so much.
Okay, note that Dan Gilbert's joined us again and Ms. Matazar has left. Next item on the agenda is agenda item 56. The respondent was not appearing. Right,
56 is, and I
Yes,
will
I'm
let him into
sorry.
the room.
yes, there is. And Monica will be doing that, correct?
He is in the room.
Hello, Mr. Herzog, can you hear us? Mr. Herzog, can you hear us?
He's muted.
You might have to unmute yourself.
Yes, sir, I can hear you.
There you go. Thank you. My name is Sean Lindsay. I'm the chair of the commission. Now's the opportunity to have your matter heard before us. We'll first hear from the investigator. We might have questions and then you'll have an opportunity to respond. We do ask that you be very precise with your response. We have a long agenda today. And so we look forward to hearing from you. And with that said, go ahead. Monica, Investigator Walker.
Thank you, Chair Lindsay and Commissioners. For the record, this is Monica Walker, investigator for the Commission. This is a case that I inherited as well from Hillary. So item number 56 in your reading books is a preliminary review report for an ethics case involving John Herzog, Commissioner for Curry County. The complaint alleges that Mr. Herzog may have failed to report a business, income, and office-related events on his 2021, 2022, 2023 Annual Verified Statement of Economic Interest Reports, SEIs, and may have also failed to properly declare a conflict of interest. According to the complaint, Mr. Herzog failed to report several office-related events, his position with Beacon Broadband as a member of its board of directors, his receipt of income of $1,000 or more from Coos Prairie Electric Cooperative, here called the cooperative, and he failed to list honoraria and a service fee of $1,000 or more. From staff's review of the documentation received, it appears that Mr. Herzog failed to report his attendance at a Beacon Broadband and Cooperative sponsored ribbon cutting ceremony in 2022 that he attended as a representative of local government. He failed to report his income of $1,000 or more from the cooperative and also failed to list Beacon Broadband as a business of which he is a director. Mr. Herzog's failure to report these items on his SEI report would appear to constitute violations of ORS 244060. As far as the reporting of honoraria or a service fee, staff did not find any information that would demonstrate Mr. Herzog received an honoraria or a service fee in which he would need to report. Additionally, staff's review of Mr. Herzog's alleged failure to disclose a conflict of interest appears to have been unsubstantiated, as staff's review of the meetings held by Curry County revealed that the discussion and any vote appeared to be procedural and had no financial impact on Mr. Herzog. Thus, there does not appear to be any action, decision, or recommendation taken by Mr. Herzog which would or could be a private pecuniary benefit or detriment to himself or a business in which he is associated. Therefore, it does not appear that Mr. Herzog was required to declare a conflict of interest under ORS 244120. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Mr. Herzog may have committed one or more violations of Oregon government ethics law pertaining to the filing of his 2021, 2022, and 2023 SEI reports. Therefore, the report that is in your meeting books recommends moving this case to investigation.
Thank you. The question for you is, couple of these allegations are that he failed to report. And I'm just wondering how this complainant would have even known that. Did the complainant explain how he knew that or came up with that allegation?
So just to be clear, it was a case that I inherited from Hillary. So as far as the complainant, I did not delve into it any further than I know that he is a resident of Gold Beach. But other than that, I don't know. I did do a cursory search on Google for the complainant, but that was all that I could come up with. So I'm not aware.
Yeah. Okay. I would assume that someone making that fine detail of an allegation would have to know a lot more facts or have a close relationship or something like that. But maybe Mr. Herzog might be able to clarify that a little bit. But yes, Commissioner Fiskin.
Chair, just a quick question. This can wait till after Mr. Herzog speaks or now. I would appreciate if our investigator just quickly summarize, if we were to move ahead, which we have not decided yet to do, what would be the focus of the additional work, investigation, review? What would you be looking at if we decided later in this meeting to move ahead?
I think we would most likely be proposing a stipulated final order for a settlement agreement and go to the penalty matrix to determine what ascertain as a term of the agreement.
Thank you.
Thank you.
Kira, thank you.
Commissioners, any other questions for Investigator Walker? Seeing none, Mr. Herzog, now's your opportunity. We look forward to hearing from you.
And it just, you want me to explain why Mr. Nast is after me, or?
No. My specific question was, I was just wondering how he might have even learned about you failing to report something. But now's your time to briefly summarize your response to us. And if you want to include a short snippet response to that, you're welcome to, but just your general response.
Okay, so my general response is the person that that says I did something wrong is an opponent of Beacon Broadband, and in any venture you have people who are in favor of what you're doing, and you have those that aren't, and that's his only reason. I apologize for not stating that on my SEI. I am a very poor politician. I'm at the mercy of you guys, and I just want you to know I didn't do anything on purpose or trying to get away with anything, and I will pay any fines or whatever penalty.
Okay, thank you, Mr. Herzog. We appreciate your service as well, public service. Commissioners, any questions for Mr. Herzog that you might have? Yeah, Commissioner Thompson.
I don't know if you can answer this or not, Investigator Walker, but based on the penalty matrix, are we in letter of education land or where?
I would refer to Susan on that question.
So, yes, I think especially when it comes to an SEI reporting issue, unless they have had a prior violation, if it's their first time, our initial proposal would be for a letter of education. And one of the reasons we want to do that is I fully understand that you didn't know, it's confusing, is having the stipulated final order in the letter of education then creates gives us the opportunity to educate, but creates the record so that if there are future failure to reports, we have the basis to.
All right, seeing no other comments, I like that direction. That's just so the commission knows where I'm leaning is I like underlying the may and heading toward that direction. So Vice Chair Fiskin, do you have a motion?
Mr. Chair, I do. Again, if you allow me just a brief preamble, this strikes me as an example of where I, as one commissioner, would like to have the ability to make a final decision as a result of the review so far, rather than moving to an investigation. But with that personal comment, on at least my memory, my record, I will hereby move that the commission find there is a substantial objective basis for believing that Mr. John Herzog may have violated ORS 244.060 and that the commission should investigate accordingly.
Thank you, commissioners. Any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Burke,
I vote aye.
Commissioner Thompson,
Aye.
Commissioner Fiskum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you, Commissioner Herzog. What this means is we have not found any violation. We've simply decided to proceed further with the investigation, which means that our staff will be in contact with you. And I think you've heard where we're inclined, where we envision where this will end. And we thank you for being with us today.
Thank you, sir.
Thank you. You have a good day.
You too. Bye.
Okay, commissioners, we're moving on to agenda item 57, who will be attending via Teams.
And we just lost him. Okay, let's go. Oh, here he is. We are letting him into the room.
Yeah. Hello, Mr. Hawkins. Welcome. Can you hear us okay?
I can, thank you.
Thank you. My name's Sean Lindsay. I serve as the chair of the commission. And now's the opportunity to have your matter heard before us. Procedurally, our investigator is going to give a report to the commission, and then you'll have an opportunity to provide a response. We do ask that you be brief and precise, considering our long agenda today, and then we'll proceed that way. So thank you for being with us today. And I understand it's Investigator McIntyre.
Correct.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item number 57 is a preliminary review for David Hawkins, Deputy Facility Director with the Oregon Department of Human Resources. The complaint in this matter is brought forth by a senior internal human resource investigator with ODHS. They brought forth in the complaint, they brought forth one issue during the investigation. Another potential issue was also brought forth and presented to Mr. Hawkins. So the first potential issue concerns Mr. Hawkins using a state vehicle to commute to and from his personal residence in Estacada and what appears to be his official workstation in Salem, Oregon, and doing so on at least 25 occasions, and also using the state's fuel card to pay for the associated gas. Both the complainant and Mr. Hawkins did agree that Mr. Hawkins was authorized to store the vehicle at his personal residence. Mr. Hawkins also acknowledged that he used the state vehicle to drive from his home to the Salem, Oregon office, but his argument was that was within his purview and it was authorized by his supervisor. Therefore, at this time, the question is whether Mr. Hawkins' use of the state vehicle and the associated fuel card was consistent with his supervisor's authorization and policy. So that's what we would look at in the investigation. It does appear at this time, though, that he may have used the state vehicle for his own personal use in violation of ORS 244040 subsection 1, which would also be using the state fuel card to pay for the associated gas. And he would have been met with an actual conflict of interest in violation of that statute as well, 244.1201C, for not disclosing that conflict of interest that would have been associated each time he would have used the vehicle or paid for the gas related to that trip. The other issue is that was potentially brought up was that Mr. Hawkins may have violated ORS 244.0251 when he accepted free lunches by a company called Rubicon and their subcontractors. Not clear on when this occurred. It was just stated throughout the year. It does appear that Rubicon and the subcontractors may have provided more than $50 worth of lunches to Mr. Hawkins throughout the year, that they may have an administrative or legislative interest in Mr. Hawkins and his position and what he does. It also potentially, the acceptance of those free lunches may fall within a gift exception as well. So that is something that we would look into if this were to move to investigation. However, at this time, based on the information during the preliminary review, there does appear to be a substantial objective basis to believe that Mr. David Hawkins' use of the state vehicle, use of the state fuel card, may have violated ORS 244.0401, and he failed to disclose the associated conflicts of interest as required by ORS 244.1201C. Also, a substantial objective basis to believe that he may have violated ORS 244.025 when he accepted these free lunches in excess of what appears or may have been more than $50. And therefore, the report in your book recommends that these matters be moved to investigation.
Thank you.
Thank you.
Commissioners, any comments for Investigator McIntyre? Seeing none, Mr. Hawkins, now is your opportunity, and we look forward to hearing from you.
Well, thank you. I appreciate the time, and I will keep it brief because I know you're busy and you've had the report in front of you, and hopefully you've had a chance to review that. But there are a few things that I do want to bring forward in regards to the report and the accusations that are coming forward. First of all, I've been with the state for 15 years, and over those 15 years, there has absolutely never been a motive for personal gain in my own life. That is not something that I do. I'm a man of integrity, and the opportunity that I have to serve the people of Oregon through the facilities that I work in, I truly respect that. And so there has never been a motive for personal gain in any of my actions throughout the 15 years that I've devoted to. And I'm one that has always been given or do give 120% each day. As you can look at my calendar throughout the years, if there's any question of the meetings and the opportunities to be all over the state, because of the facilities we provide and the things that we do. So there's never been anything of a personal gain in anything. The guidelines, I appreciate guidelines and I appreciate rules that are set up, and I try to uphold those at all times. And if there is ever a question in regards to that brought to my attention, I would absolutely uphold and do as asked or do as required. So in the report, I would like to refer to a couple of things. On page 6 of the report, I don't know if you have the report in front of you.
You do.
Okay. Page 6, line items 3 and 4 and 5. It talks about the amount of mileage and the cost associated to that throughout that entire period of time. In question, there is 25 trips that are in question. So in here, it states that it's, 14,665 miles driven during that period of time, which is true. I mean, I drive, like I mentioned, I drive a lot for the state, or I did drive quite a bit for the state with projects all over from Cape Falls to Ontario to the coast and all over. So the 14,665 is correct. I just wanted to clarify that there's 25 trips that are in question, and that would only be 2,400 miles is what that would be. So don't look at that 14,000, that 14,000 miles is in violation by Dave Hawkins. If there is a violation, it's only 2,400 miles that would have been used, as they say, for personal gain, which I completely disagree with. And the cost associated to that, right? From my home to the to the Salem office is 49 miles one way, is what it is. So if this goes forward, please take that in consideration, that the sticker shock of 14,665 miles and $4,788 is not true to the impact of what they're trying to say in this bringing forward. The vehicle was never used at all for personal use. I have vehicles of my own that sit here at my home, as did the truck during the time that I was able to have the truck here at home. It was never used for personal use by myself or anyone else. It was used always for business. I mentioned my calendar earlier, and if you have access, or I'd like to bring that forward, is something to look at. My calendar, you see in the report on page, sorry, I didn't have this one tagged, but if you see on the report on page 5 of all the times that the vehicle was fueled, those dates are true. It's because I traveled a lot for the state of Oregon, just because of the need and desires of the job, and because of COVID and lack of staff members. I did travel a lot during that period of time, as those dates that are true, that I did fuel the vehicle, but that was all because of state business and needs for that piece. I would like to go to, just to make a point, on page number 7 and 8. On page 7, line item 31, and then it continues on page 8, lines 1, 2, and 3. It says, prior to Karuna coming, who's my current manager at the time. I'm sorry, before I go on, can everyone hear me okay?
Yes.
Okay, thank you. Sorry, I just wanted to make sure. Karuna coming on board, who's my current manager since September of 23, when this was brought forward. Prior leadership had said nothing about the use of the truck or questioned the trips that I had made. That's when those 25 trips were made, when I had 4 other managers during that period of time. Glenn Basin, Seth Lyons, Sarah Lambert, and Don Erickson were my managers at the time. And nothing was ever raised or a flag was brought forward in regards to the usage of the truck. Honestly, if something had been brought forward during that period of time, it would have been addressed and it wouldn't have happened. So it's not that I did anything. If I did anything, it was not knowingly that it was wrong. As I had, as mentioned in the letter, the truck usage had been approved by my manager at the time, Glenn Basin, who is now retired and moved on. It was approved to have the vehicle because of the circumstances that we face with facilities, because we do serve 165 buildings in the state. We do have shortage of staff. And it was during COVID period of time. So the vehicle was here at home to be used and to be utilized to be able to provide services to those buildings during those times and to be able to do as needed. As we know, during that period of time, there was unprecedented things that had to happen and things that needed to be done. And that's why the vehicle was at my home, was for that purpose and that reason, was to be able to be used on state business to address those items as they came up. As you know, working for the Office of Facilities, it changes from day to day, hour to hour, and opportunities go different directions all of the time. And that's the purpose, to have the vehicle for more efficiency and ability to address items in a timely manner as they came up. But as mentioned, any of my managers throughout this period of time of question had never said anything or had any concerns about the usage of the truck. And if I mentioned, what had been questioned, it could have been addressed and done in a different manner or changed during that period of time, after maybe one violation, or what we're calling a violation, or 2 violations, but obviously it didn't take 25 violations to get there to where we are today.
Sure.
So in the document, also just to point out, there was a question about, or a comment about, the conflict of interest. So I'm on page 11 for a couple of points, if you would like to follow. Line item number 6. Mr. Hawkins would have been required to make a written conflict of interest disclosure, his appointing authority, in his case, his manager, if any of these occasions. It appears that Mr. Hawkins may have violated. In regards to conflict of interest, and my understanding of that, I have done those when needed in the past. Was not aware of the usage of the truck as was being used was a violation or a need for a conflict of interest. Again, if someone would have asked for a conflict of interest to be submitted, it absolutely would have been submitted. But to me, this was not something that was of the need of a conflict of interest, because it had been approved by my manager to use the truck and to do the things that we did to provide services to the Oregonians of Oregon, or the people of Oregon, and also the staff that we served, the 13,000 staff that we serve throughout the state. So a conflict of interest was not on my radar, not even thought of a need to be able to do, nor was it brought to my attention by anyone in regards to the truck usage. When it was a question of other items, yes, conflict of interests were filled out, things were taken care of. When there was other things that were of question, or things that I felt were maybe something that needed to be brought forward in a conflict of interest, but this was not one that was. On that same page, I'd like to point out where it says on line item on line 26, 25 and 26, it does not appear that the lunches were offered to members of the public who were not public officials on the same terms and conditions. This is a false statement. I was not the only one in attendance at these luncheons when these luncheons happened. There was contractors, there was vendors, there was people of the public that were a part of who are not public officials. It was not just a lunch for Dave. It was not just something that came to Dave. It was given to others. And the purpose and the reason behind the lunches as they were is because at the time we had multiple projects. And it was that there was an efficiency to go from meeting to meeting with a luncheon, potentially in between or at part of, instead of having to break for lunch. Because at the time of this, that's in question, we were building the building in Gresham, and we were also building the building in Cave Falls that DHS has now completed. They were both going at the same time. And so this was a part of an efficiency aspect that was brought forward. And it was an ability to do such. There was never any gain from the lunch for me or for Rubicon. There was never a gain. I'm not an elected official that can direct things. Leases and agreements and all of that have already been in place and approved and signed. There was no gain by Rubicon that provided the lunch in any aspect of that.
Mr. Hawkins, thank you. We're letting you go a little bit longer than normal.
I
Do you want to
apologize.
wrap up, please?
Yes, I would. Thank you, Sean. I apologize for taking too long. Just to reiterate that I mentioned earlier is I have been with the state for 15 years, and there has never been any sort of desire or motive during that period of time for personal gain from the positions that I've held. Stewardship and responsibility are very important to me. And so is my integrity amongst people. To me, that is being questioned here in a false manner. And I have done nothing but give all that I can for the state of Oregon for the period of time that I've worked here. And I've appreciated that. And this is something there is not anything in my files of any sort of conduct or performance or any concerns that have ever been questioned by anyone in my actions and in my performance over the years. There's nothing that can be brought forward. And I've brought that to this group, not this group, but the groups that are bringing this forward with HR and others. There's not one thing that they can bring forward and say that was of a negative impact in my career. Thank you for your time.
Thank you, Mr. Hawkins. We appreciate your service as well. Commissioners, any comments or questions that you might want to ask of Mr. Hawkins? Okay, seeing none, we're prepared to make a motion. Mr. Hawkins, I do want to make clear that we're not making a decision of any violation today. We're simply making a decision whether we need to proceed further to iron out some facts or not. That's the question before us. I'll tell you where I'm at personally, and I'd be interested in hearing where the commissioners are. It seems to me that we need to iron out some facts, verify some statements that have been represented. And because of that, I think procedurally it'd be good to move forward just to verify those statements, but of course not making any decision of any violation. But that said, commissioners, anybody prepared to make a motion?
Mr. Chair, I am prepared to make a motion with a couple comments, if you'll indulge me. First, thanks to our investigator for emphasizing if we were to move ahead, what it is we would look at. Thank you for your comments about the need to do so. Secondly, thank Mr. Hawkins for his appearance today and the apparent sincerity of your remarks, sir. Thank you for being here. One further comment from me is that at first blush, as I looked at this, it struck me that this could have been a kind of issue that could be resolved internally at DHS without bringing this issue to us. That said, if the issue is coming to us under the Oregon laws, we're responsible to administer and enforce. The other part of me says, so be it. So, Mr. Chair, I do have a motion if you're ready.
Sure, go ahead.
The motion is, Mr. Chair, to hereby move the commission find there is a substantial objective basis for believing that David Hawkins may have violated ORS 244.040 sub 1, ORS 244.120 sub 1, and ORS 244.025 sub 1, and that the commission should investigate accordingly.
Thank you. Commissioners, any comments on the motion or any alternative motions? Seeing none, we'll call for the vote.
Commissioner Thompson.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Hollister.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Chair Lindsay.
Aye.
Motion pass 8-0.
Thank you. Mr. Hawkins, again, I want to make sure that you fully understand this is not a decision of any violation in any way. It's simply a procedural motion to proceed forward. And as we've discussed, it's really to verify a lot of the facts that have been represented to us. And I suspect that there will be a resolution that you're satisfied here with shortly, maybe even a vindication. And so thank you for being with us today, and our staff will be in touch soon.
Thank you very much, everyone, for your time. I appreciate
Thank you. Thank you.
Thank you. Bye-bye.
All right, commissioners, we're now going to move on to agenda items 58 through 61. They've waived, and actually 58 through 60 have waived to be heard. Okay. So not 61.
Correct. The unfortunate could not provide.
Okay, so we're going to do 58 through 60. And as you saw, Investigator Pacheco is going to report on that.
Yep, and I'm letting them into the room now.
Mr. Chair, just a quick comment as we wait. I found it interesting, no disrespect intended, in fact, respect. This was for Mr. Hawkins, it was an emotional experience. I think
In the room. Right.
it's fine. So I think that's just an important thing to understand as we go forward. So thank you, and I'll stop right there in light of the next item on the agenda.
Thank you.
Please.
All right, welcome, Miss Mars, Mr. Mars, and Mr. Long. Can you hear us okay?
Yes.
Yes.
Okay, thank you. My name is Sean Lindsay. I'm the chair of the commission. And now is the time for your matter to be heard before the commission. We appreciate you being with us today. Procedurally, what's going to happen is Investigator Pacheco is going to report to us on his preliminary review. And then you will have an opportunity to respond as well. We do have a very long agenda today, so we ask that in any response, you don't even have to respond, but if any response, that it be precise and brief, and that preferably one of you speak for the three of you. And with that said, we'll proceed that way. Investigator Pacheco.
Chair Lindsay and Commissioners, this is Investigator Daniel Pacheco for the record. Agenda items 58, 59, and 60 in your meeting books are preliminary review reports for 3 public officials for the city of Shaniko. The preliminary review reports are different but related, and all 3 city members have waived confidentiality to have the reports heard as one. For background, the city of Shaniko is a small town in eastern Oregon with a population of roughly 30 people. Due to its size, many of the local residents volunteer in the city's operations, such as Public Works and the local fire department. In this case, the lack of resources has contributed to poor record keeping, lack of policies and procedures, and resulted in the termination of the city's legal pro bono services and insurance coverage. The complainant in this case alleges that Diana Mars, city reporter, David Long, city council president and assistant fire chief, and Scott Mars, city fire chief, were met with conflicts of interest and used their positions for financial gain. Submitted with the complaint were a series of checks signed by Diana Mars, with one that she issued to herself and the rest made payable to her husband Scott Mars and David Long. In their responses, all 3 report that the city checks they received were for reimbursements, which were first approved by the city council. They report reimbursements for refilling a fuel dispensing system, a lift rental, miscellaneous purchases, and payments from the Oregon Departments of Forestry's Volunteer Fire Assistance Grant, or VFA. For context, the VFA grant allows reimbursements on eligible purchases for fire agencies with a limited budget and population of less than 20,000 people. In their cases, commission staff were able to verify one check in which Mrs. Mars issued to herself. However, staff were unable to corroborate the remaining checks issued to Scott Mars or David Long through other methods such as receipts. In addition, commission staff were unable to locate meeting minutes confirming the council's approval for most of the checks. Per RS 244.120 sub 1 sub C, when a public official such as Diana Mars or Scott Mars is met with a conflict of interest, they must notify in writing to the person who appointed them on the nature of their conflict and dispose of the matter as specified by the affected authority. For RS 244.120 sub 2, when a public official such as David Long is met with a conflict of interest, they must announce the nature of their conflict, and if it is an actual conflict of interest, they are prohibited from voting on the matter that gives rise to the conflict unless their vote is required to meet the minimum vote requirement. It does not appear that Diana Mars discloses her conflict of interest to the city council, which is her appointed authority, prior to signing the checks to herself and Scott Mars. For Scott Mars, because commission staff were unable to verify the reimbursements, it is unclear whether he was issued legitimate checks by the city and therefore met with a conflict of interest. In the case of Mr. Long, it appears he may have abstained from voting on only one of his 4 checks. However, it appears he may have failed to publicly announce the nature of his conflict of interest. In addition, commission staff were unable to corroborate if he announced a conflict of interest on the remaining 3 checks and abstained from voting. Finally, for RS 244.040 sub 1, a public official may not use their position to obtain a financial gain or avoid a financial detriment that would not otherwise be available. In this case, it does not appear that Diana Mars used her position to benefit herself, but it is unclear whether she used her official position to benefit her husband. For Scott Mars, it is also unclear the payments he received were for reimbursements of expenses he incurred as his role as fire chief, and if so, then the use of office would not apply. Finally, for Mr. Long, without receipts verifying the checks as reimbursements, it is also unclear whether he used his official position for financial gain. Should these cases move to investigation, commission staff would seek to corroborate the expenses all 3 claimed as reimbursements. Next, for Diana and Scott Mars, commission staff would need to determine whether the city council approved their reimbursements. In addition, for Scott Mars, commission staff would seek to determine if the reimbursements he received arose out of his duties as the fire chief. And finally, for Mr. Long, commission staff would need to determine whether he made a public announcement on the nature of his conflicts of interest and whether he abstained from voting each time regarding his reimbursements. The recommendation in your books is to move these cases for Diana Mars, Scott Mars, and Mr. Long to investigation. Thank you.
Thank you, Investigator Pacheco. Commissioners, any questions for Investigator Pacheco? Thank you. Seeing none, Ms. Mars, Mr. Mars, Mr. Long, are one of you going to be speaking for the three of you or? Not
I guess I
unsure.
just got volunteered.
Okay, all right. Go ahead, and we do remind you to hopefully be brief and precise. Thank you. Go ahead, Ms. Mars.
I don't even know where to begin. What is?
Well, just so you know, I mean, you don't even have to respond if you don't want to, but now is your opportunity to provide a response to the allegation if you want. You don't have to, but if you want to, that's fine. If not, we can just proceed.
Well, we're all on the same contention that we've, lack of training, lack of the initial, when we came on in council in October, I think that was about the third council change. So we walked in with no training, no one to assist us, trying to figure out what people have done. Conflict of interest, we probably, I know in my case, didn't think about because I don't have any voting privileges. So to me, I'm writing a check as part of my job, doing what I'm supposed to. If it was written to me, I had the mayor sign it because we're the only two that can sign. And same with Mr. Mars, he's not on the council, he's the volunteer fire chief. So he has no voting privileges. And it may have been a mistake. I know Mr. Long has been really good about always saying there's a conflict of interest and abstaining, but we've changed a lot of things. Nothing's being, well, I won't say nothing. We do have one or two reimbursements. Usually everything, I do a finance sheet, tell them what's being paid, who's being paid, and council has to approve it before I write a check.
Sure. Okay.
What?
May I add something in addition?
Go ahead.
This is Scott Mars. We have done a lot of training with CIS insurance as well as LOC. We go through a lot of what they require. Conflict of interest training also is a big part of that, budget training and a number of other things. So we've gone through a lot of that. So we're thinking that we're dialed in on that fairly well. Whether there's things missing, we actually have a meeting scheduled here soon.
June 11th, we have a 2-hour meeting with the Ethics Commission on conflict of interest.
So yeah, if there's any holes there that we're missing, I'm sure that will come up there.
Thank you. Thank you for.
Mr. Long wanted to say something too.
Sure.
Yeah, I mean, on just the thing with the reimbursements. I mean, most of that was for, equipment and things through ODF on that grant purpose. So once that was declared, I always declared a potential or a actual conflict of interest, depending on what it was, and did not vote. Even when I've had older council members say, well, you don't need to do that, I did it anyway, just in case, because I was receiving money.
Thank you. All right. Well, thank you. And again, we appreciate you being with us today. I agree with you that there might just need to be some facts ironed out and some training to button up any holes. And a lot of that is the purpose of this very meeting, is to give you a heads up, give you some correction, and everybody moves on happily. And we appreciate you and your service. So that said, any questions of the respondents from the commissioners? Seeing none, Mr. Fiscum, it looks like you might be prepared to make a motion.
Mr. Chair, I am prepared to make a motion. I hereby move that the commission find there is a substantial objective basis for believing that Ms. Diana Mars may have violated ORS 244.120 sub 1 sub C and ORS 244.040 sub 1, and that the commission should investigate accordingly.
Any comments on the motion?
Sure.
Yes, Commissioner Thompson.
I appreciate the motion. I'm torn on this one because the comments about how the city council was voting on finance sheets and approving finance sheets before checks were cut. Is there potentially a technical violation? Sure, but I'm also swayed by the fact that we're talking about a town of 30 people. So, I mean, there's more people, there's probably 3 times that many people working in this building today. So and balance that with the fact that they have taken things over. They are getting the necessary training, including with this office. I don't know. I'm struggling with this one.
I'll make a comment on that as well. You're right. The process here in my mind is to proceed with an investigation. Through that investigation, there's usually a letter of education or a procedure of education to correct some things, but that's already locked in. That's already happening. So are we being duplicative here or not? Any comments on that from anybody else, commissioners?
Mr. Chair, I'll withdraw my motion for the moment.
Yes,
Mr. Chair, this is Commissioner Burke. I'm sorry I can't raise my hand. I agree with this completely, and I would be, actually, I would like, unless Chair Fiscum objects, I would like to make a motion that we dismiss this case.
Yeah, before we make that motion, I want to give all the commissioners to make a, I know that Vice Chair has just withdrawn his motion, but Commissioner Hollister.
That's fine.
Thank you, Chair. I think I would just like to agree with some of the sentiments expressed by my fellow commissioners. I do note in listening to the respondents that they seem to be making a strong effort to receive education, and I think that that's admirable. I'm glad to hear that they've already lined up training with the Ethics Commission, and thanks to our staff for facilitating that. I think that in cases where there is an extraordinarily small number of individuals available, it can be even more challenging to comply with conflicts requirements. And so in some ways you have more burden on a community that can less afford to bear it. And so I certainly stand behind all of our ethics laws and believe that they need to be applied evenly. I also think that in this instance, this might be an opportunity for us to exercise some discretion.
Thank you. Any other comments, commissioners? Seeing none, Commissioner Thompson, do you have a motion, or Commissioner Fiscum, do you have a different motion?
Commissioner Burke has made a motion. I'm pleased to reiterate that or make it myself, either way.
Sorry, I totally blew past that. Commissioner Burke, could you restate your motion?
I would like to move that we dismiss this case.
Thank you. I think that's sufficient for our purposes.
Make sure the motion reflects the name of the name of the individual involved, because there are several here. So this should make mention of the name Diana Mars.
Yes. Commissioner Burke, are you prepared to do that, or would you like Vice Chair Fiscum to take over for you?
Oh, I'm always happy to have Vice Chair Fiscum take over for me. I'm not an attorney, so I tend to botch these things, but my intention is to make motions that we dismiss the cases with regard to all the people named in this agenda item.
Mr. Chair, I will make the motion that Mr. Burke was trying to make, which is that I hereby move that the commission hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Diana Mars has violated provisions in government ethics law, ORS 244.120 sub 1 sub C and ORS 244.040 sub 1, and that nothing further is warranted with regard to view, and that this complaint be dismissed.
Thank you. Commissioners, any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Fiskum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Vice Chair Fiskum.
This is the matter involving Mr. David Long, right? We
Correct.
don't need to have the report repeated, I'm
Correct.
presuming. Thank you, Mr. Chair. I will hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. David Long has violated provisions in government ethics law or warrant further review, and that this complaint be dismissed.
Seeing no comments, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiskum,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Vice Chair Fiskum.
Mr. Chair, I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Scott Mars may have violated provisions in Oregon ethics law or warrant further review, and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiskum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you, Ms. Mars, Mr. Mars, Mr. Long. Thank you for being with us today. The matter's been dismissed. We look forward to you hearing from our staff how well the training went on June 11th, and wish you a good day.
Thank you.
Thank you.
Thank you.
Thank you. Wait for them to leave, and then we'll go to agenda item. They all out?
Yes, there were only one account left.
Okay, got it. Okay, commissioners, we're on agenda item 61, same matter, but not appearing, Mr. Trainer. Am I getting this right? All right, and investigator McIntyre, right?
No.
Pacheco, sorry, keeping it all together here. Go ahead, and we invite you to be brief.
Chairmen and Commissioners, this is Investigator Deanna Pacheco for the record. Agenda item 61 in your meeting books is a preliminary review report for Donald Trainer, Mayor for the City of Shaniko. For RS 244.040, a public official may not use their position to obtain a financial gain or avoid a financial detriment that would not otherwise be available. It is unclear if Mr. Trainer took any actions in his official capacity to obtain a financial gain or avoid a financial detriment for himself. In his case, there was the usage of stipend and reimbursements, which was used interchangeably on his checks and financial records. Again, and this was due to a poor record keeping, lack of policies and procedures, and there was also per RS 244.120, when a public official is met with a conflict of interest, they must announce the nature of their conflict, and if it is an actual conflict, they are prohibited from voting on the matter that gave rise to the conflict unless their vote is required to meet the minimum vote requirement. In this case, Mr. Trainer acknowledges he never disclosed a conflict of interest, but states he did abstain from voting each time that the council voted on his checks. Should this case move to investigation, commission staff would seek to verify the amounts that Mr. Trainer was paid, whether those payments were authorized by the city council or voters, identifying each meeting when Mr. Trainer's payments were voted on by the council, and if he abstained from voting. The recommendation in your books is to move this case to investigation. Thank you.
Thank you. Vice Chair Fiskum, do you have a motion?
Chair, I do have a motion in the spirit of our earlier actions. I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Donald Trainer has violated provisions in government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiska,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you, commissioners. Thank you, Investigator Pacheco. We're now moving on to agenda item 62, who the respondent, I understand, is not appearing. And Investigator Pacheco.
It's gonna be McIntyre.
Is reporting. Go ahead.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record, for the case that I took over from Hillary. So to summarize, agenda item number 62 is a preliminary review for David Younger, former football coach with South Albany High School in Lynn County School District 8J. Based on the information available at this time, Mr. Younger was arrested on 2 charges of theft and 1 charge of criminal trespass. He allegedly stole property totaling over $8,000 and an iPhone from the high school he worked at, student athletes, a teacher, an accountant, and a basketball coach. Mr. Younger would not have had the opportunity to commit these alleged thefts if not for his position as South Albany High School coach. Additionally, Mr. Younger may have failed to disclose the actual conflict of interest each time he may have stolen money or property, and never made a written disclosure to his appointing authority, as the law would require. Therefore, that's really all the information we have at this time. So based on that information, there does appear to be a substantial objective basis to believe that Mr. Younger may have violated ORS 244-040 and ORS 244-120 by allegedly committing these thefts associated with his official position, and once again, failing to disclose the associated conflicts of interest. Therefore, the recommendation is to move the case to investigation.
Thank you. Thank you. Commissioner McIntyre, Investigator McIntyre, thank you. And any questions, commissioners? Seeing none. Vice Chair Fiscum.
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Mr. David Younger may have violated ORS 244.040 sub 1 and ORS 244.120 sub 1, and that the commission should investigate accordingly.
Thank you. Any comments, commissioners? Seeing none, we'll call for the vote.
Commissioner Mason,
Oh, hold on. We see Commissioner Hollister.
I just am confused on the math here, and I'm sure it can be something sorted out later, but we have $10,243 raised, $3,385 allegedly spent on the season, which leaves $6,000, but then he's alleged to have stolen over $8,000. So I guess I'm confused about how the numbers add up, and maybe you could just, at the next stage, explain that to me. That's all. Thank you.
Thank you. Maybe the value of the phone, but.
Right. Like I said, I just took this case off of Hillary, so I did not do the investigation. I am not, or the preliminary review. I'm not sure how the 8,000 came up. I believe that was an article that was posted where the summary was the 8,000, where that information came from. Still very unclear at this time.
Go ahead.
I would add this, as you may recall, this case was an own motion. So the own motion was based on the newspaper articles and the information filed in the circuit court. Because it is a pending criminal matter, we don't have a lot of information, obviously, from the respondent or his attorney.
Or DOJ.
I mean, it's so. We are having to base the recommendation on the information reported in the indictment, basically, and the news media. So I agree they don't add up. In an investigation, we would look and confirm what actually was taken. I suspect the number issue that Amber identifies is a combo of what was actually taken from the lockers from the students. And there was this fundraising that had happened that some of the money did, I think, get returned.
Yeah. All right. Did we call the vote?
No.
No. Yes, go ahead.
You haven't had the roll, but
Gotta have the roll. We did call for the vote. Okay.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiskum,
aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Maybe thumbs up or down. We can't hear you.
is that an aye?
Aye.
Okay. Chair Lindsay,
Aye.
motion passed 8-0.
All right. We are moving on to agenda item 62. 63. This is. Yeah, that's what's wrong. My numbers are off on this sheet here, so.
Got 262s.
That's what it is. I got 2 62s.
Yeah, because that was David and Tyler that did not appear for it. So
Oh,
attorney
I
responded.
see.
Yeah.
Now on 63, Mr. Chair.
Okay, thank you.
Well,
Agenda item 63, go ahead.
And I'm letting in the respondent and attorney
Oh.
now.
Second.
Wait, hold on here, just a second. So 63, Tara, so Tyler,
Is the attorney for 62.
I got it.
Yes.
Sorry, folks. I'm the C student here. All right, 63.
This is pass fail, Mr. Chair, so.
So you get degrees.
A little slow. These get degrees, they do.
They've been admitted into the room.
Okay, great. Hello, Miss Trudell, are you here? Can you hear us?
Yes, I can hear you.
And we can hear you, thank you. And we also understand you have your attorney with you, Paige.
Yes, Paige Churs.
Churs, okay, thank you. Welcome, and we appreciate you being with us today. Commissioners, this is agenda item 63 on Ms. Trudell and also Ms. Trudell and Ms. Churs. We appreciate you being here today. Now's the opportunity to be heard. We're going to first hear from Investigator Pacheco procedurally. After that, you'll have an opportunity to respond. We do have a long agenda today, and so we ask that you be prepared to be brief and concise when you do respond. That said, Investigator Pacheco, please.
Thank you, Chair Lindsay and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 63 in your meeting book is a preliminary review report for Tara Trudell, former Sheriff Dispatcher for the Lynn County Sheriff's Office. The Commission opened the preliminary review on February 9th based on information contained in a news report published on sweethomeknowsnews.com. According to the report, Ms. Trudell was alleged to have taken time over a span of 3 years and accused of stealing at least $20,000 in paid time off, which was not deducted from her pay. Based on the information gathered, it appears that Ms. Trudell would request time off to her supervisor, and once it was approved, she would void the time off request, not notify her supervisor, and still take the scheduled time off, given the impression she had worked for that time. From February 9th to October 27th, 2021, it appears Ms. Trudell did this a total of 23 times. Thus, it appears the actions of her official capacity resulted in a direct financial benefit through an accumulation of vacation time, personal leave, and additional compensation for days she did not actually work. For ORS 244.120 sub 1 sub C, when a public official is met with a conflict of interest, they must notify in writing to the person who appointed them on the nature of the conflict and dispose of the matter as specified by the appointed authority. In this case, it appears that after voiding each time off request, Ms. Trudell was met with the actual conflict of interest, as her actions would result in a financial benefit of additional compensation for days she did not work. In addition, per ORS 244.040 sub 1, a public official may not use their position to obtain a financial gain or avoid a financial detriment that would not otherwise be available. In this case, it appears Ms. Trudell used her official position as a sheriff dispatcher to not only falsify her time slips to obtain a financial gain and accumulate vacation and personal leave for work she did not actually do, an opportunity available to her but for her official position. Commission staff do note some additional considerations, in particular ORS 244.390 sub 2, which provides that, quote, before making a finding, there is cost to undertake an investigation, and before imposing a civil penalty, the commission shall consider the public interest in any other penalty or sanction that has been or may be imposed on the public official as a result of the same conduct as subject of the action by the commission under ORS 244.260, end quote. In this case, Ms. Chers, Ms. Trudell's attorney points out that Ms. Trudell has already faced significant penalties resulting from her actions. This includes pleading guilty to a felony, giving up her certification, spent 10 days in jails, and has already paid restitution in the amount of $19,067.23. Based on the information collected in this preliminary review, there appears to be a substantial objective basis to believe that Tara Trudell may have violated Oregon government ethics laws, and the recommendation in your book is to move this case to investigation. Thank you.
Thank you. Commissioners, any questions that you might have for Investigator Pacheco? Seeing none, Ms. Chers, now is your opportunity to respond. We look forward to hearing from you.
So I don't have too much to add that Mr. Pacheco said, other than I just don't really see the public interest in moving forward with this review. I mean, she's a felon, spent 10 days in jail. I mean, I just don't see the public interest in moving forward with this investigation. Ms. Trudell would like to move forward with her life, and she's already suffered great discipline as a result of this, and I just don't see the public interest in moving forward with it, especially under ORS 244.390 that was cited previously. It's the same conduct, and she's already faced severe penalty and sanctions, and she will not ever work as a dispatcher again. And that's all I have.
Thank you. We appreciate your sincerity and transparency and being here today and personally appearing as well as you, Mr. Trudell. All right, commissioners, now's the opportunity for us to decide whether we're going to proceed or not. I'll tell you where I'm at. Until I heard these last kind of comments, my thought was it's clear we need to proceed. We need to clear it up. We need to iron it out. At the same time, is this just spiking the football or lumping on or whatever other metaphor you want to use? I don't think I've experienced this in my tenure yet. So I look forward, maybe get some comment from Executive Director Myers or Vice Chair Fiscom or Commissioner Mason, who's been around a little bit. You guys have any comments on that? Or is anybody just prepared to make a motion as well?
Mr. Chair, I'm still thinking about my specific comment, but I would just endorse your advocacy for yours and my colleagues to consider making comments such as Ms. Hollister may be willing to make in a moment, seeing her hand up, as to this issue of this individual has already, quote, paid a penalty, unquote. Now this looks like it's, to give you a third image, piling on. I'm not saying it is. It looks like it could be that. So I'd be interested in any other comments from colleagues on that before I decide what my comment is. Thank you.
Yeah, Commissioner Hollister.
Thank you, Chair. I think that in an instance like this, it's important for us to continue with the investigation in order to uphold public trust in the process. And if at the penalty stage, we believe that it would be piling on to enforce a significant monetary penalty, then I think that's the appropriate place for that discussion.
Thank you. Commissioner Payne.
I second Chair Hollister's comments, and I also note that the statute that's cited by the statute ORS 244.390 section 1, not just section 2, says that penalty or sanctions imposed by our commission are in addition to and not in lieu of other penalties or sanctions. And I understand that there's a public interest aspect here, but I do think that our commission serves a different purpose than criminal sanctions. And even if that's education or some other purpose, I do think it's still important that we serve our purpose as a commission and do not step aside simply because a criminal process has occurred, considering our jurisdiction and the purposes that our commission serves here. So I second Chair Hollister's comments. I do think we should proceed and serve our purposes that our commission serves here.
Well said. Thank you. Very
Mr. Chair?
persuasive from both of you. Yes, Commissioner Burke.
I just wanted to add that, I'm sensitive to the concept of piling on. This person is clearly, as has been said, going to pay a high price for these crimes, assuming there's a conviction. But I think that it would be very difficult for us. We have proceeded with innumerable cases that are less egregious than this one is. And I think it would send a very poor signal if we were to decide to do nothing here, given our obligation to ensure that ethics laws are enforced and that, the educational function is not just to the respondent. The educational function is also to public officials in the entire state and the public at large. And I think it undermines our educational function if we don't proceed on charges that are this egregious. That's all.
Thank you. Any other comments? Seeing none.
Chair, thank you for colleagues. Thank you for those comments. Appreciate that. I and others appreciate them in this room. Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Tyra Trudell may have violated ORS 244.120 sub 1 sub C and ORS 244.040 sub 1, and that the commission should investigate accordingly.
Thank you. I echo my thanks as well. I think those were very persuasive comments from my fellow commissioners, and I'll be supporting this motion. Any other comments? Seeing none, we'll call for the vote.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you.
Filed.
Yeah, let's take a 10-minute break, folks, and we'll come back and do agenda item 64 when we're back. We'll see you at 10:40. All right, commissioners. I don't know if Commissioner Hollister, Commissioner Payne, can you hear me? Are you back yet? There's Commissioner Payne, Commissioner McCauley. It's technically not 10:40 yet, so we'll wait till the phone turns the magical number. Commissioner Burke, can you hear me? National iPhone time. Commissioner Mason?
Here.
Okay. And Commissioner Hollister, correct? Not back yet? Got 1, 2, 3.
Looks like Amber's there on the left, far left.
I'm here, Mr. Chair, Commissioner Burke. You know, when I unmute, it's about 4 seconds before my mic is live, so I'm sorry for the delay.
That's just fine. Thank you. All right. Give Amber just a second more here. All right, Commissioner Hollister, are you there? That's okay, we can proceed. So, okay, we're back in executive session and we're now addressing agenda item 64. And Ms. Legaspi, am I saying that correct? Chair Legaspi, I should say, welcome. Thanks for being with us today. My name is Sean Lindsay. I'm the chair of the commission. And what will happen now's the moment for your matter to be heard before the commission. And what's going to happen procedurally is that Investigator Pacheco is going to report on his preliminary review to the commission. And then we may have some questions of him. And then we'll give you an opportunity to speak to us as well. And if you want, you don't have to, but if you want to, you're welcome to. We do have a long agenda today, though, so we do ask that you be brief and precise. And with that said, Investigator Pacheco will go ahead. Thank you.
Thank you, Chair Lindsay and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 64 in your meeting book is a preliminary review report for Noemi Legaspi, Chair and Board of Directors for the Woodburn School District. In this case, as a district board member and chair, Ms. Legaspi's responsibilities include implementing policies, reviewing staff contracts, authorizing financial affairs, and setting the budget. The complainant in this case alleges that Ms. Legaspi may have violated Oregon government ethic laws when she approached the Woodburn School District, offered to provide mental health services, and was subsequently contracted as a mental health provider. In her response, Ms. Legaspi states that in her communications to district staff, she never advertised her position as a board member and specifically requested a separate district email to distinguish between her role on the board and her counseling business. Per ORS 244.120 sub 2, when a public official is met with a conflict of interest, they must announce the nature of the conflict, and if it is an actual conflict of interest, they are prohibited from voting on the matter that gave rise to the conflict unless their vote is required to meet the minimum vote requirement. In this case, it appears Ms. Legaspi may have been met with a conflict of interest and did not disclose her conflict when she voted to approve an Oregon Department of Education grant on December 12, 2023, which provided the district with funding for mental and behavioral health support. According to district staff, this grant could be used to fund Ms. Legaspi's business contract, thereby potentially leading to a financial benefit to Ms. Legaspi and her business. In addition, per ORS 244.040 sub 1, it is not allowable for a public official to create an opportunity for themselves, a relative, or a business with which they are associated with, which could result in a financial benefit or detriment. Based on the information in this preliminary review, it appears that Ms. Legaspi approached the district as a private vendor and was contracted as such. However, it does appear that Ms. Legaspi may have been attempting to use her position with the district to gain new clients for her business before she was contracted. According to Ms. Legaspi, she has provided lectures at one of her child's schools on mental health, and reports from 3 different district staff members indicate Ms. Legaspi has attended parent-teacher conferences and promoted her counseling services to parents and staff. Commission staff do note that the class exception could apply where Ms. Legaspi would not be met with a conflict of interest or need to make a disclosure at the time she voted on the Oregon Department of Education grant on December 12th. While the commission has issued a staff advisor opinion identifying a class in instances of a board approving a budget as a whole, in this case, Ms. Legaspi is only one of 3 mental health vendors currently contracted with the district. Furthermore, she is also part of the governing body responsible for making recommendations, voting, and approving the district's budget. Should this case move to investigation, additional analysis may be needed to make this class determination. Because of Ms. Legaspi's decision to serve the district as a chair and as a private vendor, it has resulted in her facing unique challenges in attempting to fulfill both of her roles while still complying with the provisions in ORS Chapter 244. Should this case move to investigation, commission staff would seek to identify the following. 1, as previously stated, additional analysis in making a class determination. 2, if Ms. Legaspi participated in approving the budget which allocated funding to her mental health contract and whether she was met with any additional conflicts of interest since entry into contract with the district. 3, if the benefits for her counseling business that she received were a result of her official position. This included a school referral form, a place to meet with students, and a Woodburn School District email to conduct her personal business. And lastly, 4, if Ms. Legaspi attended the parent-teacher conferences as a parent, counselor, or as a board member, what discussions she had, if she discussed her status as a board member, and if she obtained new clients because of them. The recommendation in your books is to move this case to investigation. Thank you.
Thank you, Investigator Pacheco. First question I have for you is I understand that she voted on the approval of the grant. How clear is it that voting on that is actually also voting on payment or contract payment to her in her official capacity? Is it, because I could see voting for some big things, but it's not really clear that, oh, had I known I was voting, it was affecting that. That's where I'm a little caught up right now, is how clear and bright lined is that?
So that would be something that we would have to consider if it were to go to investigation, seeing, because it's just more of the potential on that end.
Right. Okay.
Mr. Chair, I got a quick question for Mr. Pacheco, Executive Director or Council. Remind me what the process is that we, the collective we, need to go through if the issue is establishing a class. How is that done and what do we have to do that rather than just saying there is a class, which is not adequate, I'm remembering, but what's the process?
So in order to apply the class exception, you have to first determine that there is a class. So that determination would require fact-specific findings that the class consists of these members who all share the same characteristics, whether it is all mental health counselors, only those mental health counselors with contracts with the district, or all that could have contracts. So you have to first make that determination of who would be in the class. And then the second step would be to confirm or determine that all members of that identified class are affected to the same degree.
And that would require moving to investigation.
Just a quick additional question, which is sort of that question. Thank you, Mr. Chair, is that you've described is staff work that would need to be done by you and colleagues and presented to us to establish the existence of a class. It couldn't just be something we rule offhandedly, pardon that word, on the basis of a motion we would choose to make, but it would have to be in response to the staff work you and your staff do relative to that you described, the existence of a class and how it affects a matter.
So the commission has the authority to adopt a rule that specifies what classes exist out there and has not done so. In the absence of that, there are two ways of establishing a class. Someone can ask us in advance, and the commission can issue a determination through an advisory opinion, or in the course of the investigation and in the investigation report, our staff could provide the commission with the factual information needed for it to make its determination at the end of the investigation.
Thank you, Chair.
Including a recommendation that a class be found.
Yes. Thank you, Chair.
Yeah. Commissioners, any other questions for Investigator Pacheco? All right, seeing none. Chair Legaspi, now's your opportunity to respond. We look forward to hearing from you.
I do have a statement. Does that mean I can read it?
Sure, yeah, that's just fine.
I do have some copies. If those who would like a copy, and
I'll take one.
it sounds like I was told I have 5 minutes, so I only highlighted what I will.
Sure, that's fine.
Might just speak up a little bit if you don't mind because of the folks on the screen. Thank you very much.
Members of the Oregon Ethics Commission, I am Noemi Legaspi. Vengo Latina Mental Commission dedicated to serving the diverse needs of Woodburn's Latino community.
As the only Latina clinician in private practice in our area, my extensive training and over a decade of experience address a critical void in culturally and linguistically appropriate services for our community. Specializing in therapies across life stages, from infants to the elderly, and complex issues like immigration evaluations and family dynamics, I am uniquely positioned to understand and meet the specific mental health needs of our Latino residents. My professional credentials are in the final stages for licensure as both a licensed professional counselor and a licensed marriage and family therapist. The complaint brought against me suggests a potential conflict of interest, yet overlooks the essential role I play. The services I provide are not just beneficial, they are necessary. They bridge a critical gap in a system where the Latino community has historically been underserved and overlooked. Ensuring that our community's unique needs are not just understood, but actively addressed. In addressing the concerns raised about my involvement in school presentations on mental health, it is crucial to clarify both the nature of these engagements and my motivations. In April and November 2023, during a period of profound grief for our community, marked by several student tragedies, including suicide, I volunteered to provide mental health education at French Prairie Middle School, where my daughter attends. These sessions were driven by a pressing community need and my personal commitment as a concerned parent and mental health professional. At no time did I leverage my position as a school board member to initiate or facilitate these sessions. My interactions with the school were solely based on my professional expertise and parental involvement. I clearly introduced myself as a mental health clinician and a parent, deliberately omitting my mention of my role on the school board to avoid any perception of conflict. Furthermore, I did not distribute business cards, nor did I solicit any personal business or professional gain from these presentations. My focus was entirely on providing crucial information and support, guiding parents and educators on how to access mental health resources effectively. And I just want to note that these were in Spanish. It is also important to correct the record regarding the frequency of my involvement. I presented only twice, as is verifiable through multiple sources, including the French Prairie Middle School's official Facebook page and the school's district calendar. They should be viewed as what they truly were, acts of community service in response to critical needs, not as potential conflict of interest. My contract with the district was approved in October 2023, was agreed upon without any specifications or indication from the district as to which funds would be utilized for payment. At the time of signing, there was no discussion or implication that the ODE grant would later be involved in financing the contract. This is a crucial point, underscoring that my acceptance of the contract was based on the available information at that time, which did not include any or knowledge of specific grant funds. In November 2023, the Student Investment Account Grant Agreement was first introduced on the agenda, and it was subsequently approved in December 2023. It is imperative to note that during its approval, there was no discussion or mention of my involvement, nor was there any indication that this grant is specifically earmarked to fund my contract. The process followed standard board procedures, which are designed to handle such grants in a manner that ensures transparency and fairness without the undue influence of any single board member. The approval process for the ODE grant was conducted in full transparency, adhering to the governance standards set by our board. This included the initial presentation, subsequent inclusion in the board agenda, and final approval without any direct discussion related to my personal or professional interests. These facts are documented in the official board meeting records, which are open to public review and scrutiny. I am steadfast in my commitment to upholding the highest standards of ethics and integrity. Throughout my tenure, I refrained from engaging in any board discussions, decisions, or voting pertaining to mental health service providers, ensuring a clear separation between my roles as a board member and my professional pursuits. Understanding the paramount importance of transparency and accountability, particularly in public service, I reached out to the district to provide service with genuine sincerity. My objective is to address the mental health needs of our students with cultural sensitivity and competence. In line with this dedication, I adhere strictly to professional codes of conduct, prioritize confidentiality, and avoid any potential conflicts of interest. I pledge to disclose any such conflicts that may arise, particularly during significant decision-making process. Like budget approvals, most recently, I reached out to the Ethics Commission, OSBA, PACE, and my clinical supervisor regarding budget approval. Regarding the current ethical matters, I did not directly reach out to the Ethics Commission, as I relied on guidance from the Oregon School Board Association. In 2019, the Director of Student Services, Ms. Christie, who was interviewed in the preliminary report, approached me regarding a contracting counseling service as a private vendor. Upon consultation with OSBA, I received the confirmation that there was no conflict of interest. Over the years, I have consistently consulted with OSBA on various matters related to my profession and served as a board member, ensuring adherence to ethical guidelines, best practices. And in conclusion, I attended these school functions as a parent and not as a board member. The district's legal counsel didn't see a potential conflict of interest. I have a commitment to the profession and community. I have not profited from my contract, although there's $6,000 potentially claimed for payment. Sessions were paid by the student's insurance provider. In regards to the $6,000 listed in my contract, I have had the opportunity to use and chose not to. As stated by Ms. Christie, when a student is referred for mental health services, insurance is billed first, but the district also has money set aside to cover expenditures if a student's family has no insurance or cannot pay. Ms. Christie stated that it is possible the district has not had to pay Ms. Legaspi yet because the student's insurance is covering costs. Presently, there are 2 students on my referral list that I couldn't offer services due to my inability to bill their private insurance. Furthermore, the families could not afford the out-of-pocket fees for their private insurance, which would make them eligible for those $6,000 and could not pay. And I chose not to bill the district for those counseling services. I opted instead to refer the 2 students to other mental health providers. Thank you.
Thank you. And thank you for being here in person. It's rare that we have people come in person. It's really helpful. And also thank you for your public service. I do have a question for you. Who is Miss Kate Flanagan?
Do not know.
You do not know. Okay, thank you. Commissioners, any questions for Chair Legaspi? Go ahead, Commissioner Thompson.
Thank you for being here. Just to clarify for the record, you have a contract with the district, but you have not received any money from the district.
Correct. And I do
Ever.
not plan, right? And I do
Okay.
not plan to use those funds.
Okay, thank you very much.
Any other questions, commissioners? Seeing none, I'll tell you what my disposition is right now is I'm struggling with the idea of voting on a budget, or I guess a grant, and not knowing whether some of those funds would even ever reach the end of the row. And then on top of that, having never received any of the funds. And that's the question before us, right? Is whether she voted on a budget and did not raise her hand saying, there's a possibility that some of these funds might reach my pocket, and therefore I'm declaring a conflict.
So the determination of whether you are required to make a public announcement of conflict of interest is at the time of the decision or action being taken. Would the action, if implemented, result in a certain financial impact, or could it result? And in this case, I would say it would be a potential conflict of interest when she approves the grant, because she already had a contract to provide services as a district, and the grant could provide a financial benefit. Is it likely to? Perhaps not. It's likely that the state or insurance providers or the families or whoever will be the ones paying her bill. But clearly the purpose of the grant would be, if those things are not available, the district will step in and pay for these services using the grant funds. So it isn't whether she got any money. It's whether at the time the vote happened, was it a possibility?
Go ahead.
But wouldn't she have to have reasonable knowledge that those grant funds would be used in this case?
That they
And if,
could.
or they could be. And if she didn't, is there still, hypothetically, if she didn't know?
Well, it is incumbent on the public officials who vote to know what they're voting on. They have the individual determination.
Yeah, I thank you for that clarification. That really helps me. My position is, it seems like we're so strained to get there.
Commissioner
There's
Hollister.
several things to get to the end of the row there. I think I saw Vice Chair
Please go-
first, Commissioner Hollister, and then Vice Chair Fiscum.
Okay, thank you, Chair. I just wanted to just indicate my agreement with your comments. I think there is a point at which a potential conflict of interest becomes so attenuated that it sort of crosses the line into would a reasonable person realize there's potential conflict of interest. I think, given the respondent's experience with the system and her comments today, which I think have been really credible, I'm left with this one firm belief that she didn't have sufficient information to conclude there was a potential conflict of interest, but I do think this is sort of a case-by-case analysis that we as a commission have to take part in. And, I certainly agree with all of the executive directors Meyer's descriptions about the standard itself. I also just wanted to note that, given the disruption in our public schools over the last several years, it's really admirable when parents step up and volunteer to support their children's school communities. And I think just wanted to acknowledge.
Thank you. Vice Chair Fiscum.
Mr. Chair, I don't know where this question leads me or comment for sure, but the document that's been shared with us today and read by Ms. Gillespie was not, if I'm saying that right, pardon me for saying it wrong. I'll yield to your pronunciation. This was a document, a set of information that our investigator did not have in the review. Is that right, Mr. Pacheco? I'm not arguing that you should have. I'm saying you didn't have it within your window for preliminary review. Okay. Well, I don't know where that leaves me for sure. I guess just thinking out loud for a second, this whole issue at the moment, given what we know from our investigator and from the documents this morning, the presentation this morning, doesn't strike me as the kind of quote ethical violation unquote that demands further review by us. So I'm inclined to dismiss.
Thank you. Any further comments, commissioners? Seeing none, Vice Chair Fiscum, do you have a motion?
I will yield to my colleagues if anybody has a motion, unless I'm happy to make it.
I would welcome a motion to dismiss.
Thank you, Mr. Chair. I would move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Naomi Legaspi has violated provisions in government ethics law or warrant further review, and that this complaint be dismissed.
Thank you. Commissioners, comments on the motion before us? Seeing none, we'll call for the vote.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you, Chair Legaspi. Your matter has been dismissed.
That means.
That means it's over. It's over. So thank you for being with us today, and you enjoy the wonderful weather weekend.
You too. I hope you get out there as well.
Thank you.
Drive safely. Thank you.
One more question. So this is all public records, right? After today, everything goes.
So the report and an order of dismissal will be sent to you. And then the report and the order of dismissal do get posted to the commission's case management website.
After this meeting is over.
And a copy will be sent, obviously, to the complainant as well.
And a video recording will be posted to the website either today or Monday of this. of this. Yeah. One last question.
Yeah.
What happens, or if anything happens, are there any repercussions to people who choose to lie and make accusations?
There's no repercussion for the person who made the complaint. And so in this matter, we're not taking any action. They made an allegation. We dismissed it. That's the action. That's the public record, is that that complaint has been dismissed against you. Okay.
Well, thank you, everyone.
Thank you.
Thank you for your comments.
Today.
Andrew's over here going.
For your reports. You both call your reports.
Okay,
You're ready.
Getting all the new files.
Go ahead. Okay, commissioners, we're now on agenda item 65 regarding Lane Stratton.
He's been out of the room.
And Mr. Stratton, can you hear us?
Yes, sir.
Thank you. My name is Sean Lindsay. I'm the chair of the commission. And now is the opportunity to have your matter heard before the commission. We're going to start with investigator Walker. Hi.
Hello.
She's going to provide her report to the commission. Then you'll have an opportunity to respond if you wish. And if you do decide to make a response, we do ask that you be precise and brief, considering our long agenda today. Investigator Walker, please.
Yes, thank you, Chair Lindsay and Commissioners. For the record, this is Monica Walker, investigator for the commission. Item number 65 in your meeting books is a preliminary review report for an ethics case involving Lane Stratton, superintendent for the Lake County Educational Service District. The complaint alleges that Mr. Stratton may have used his official position to obtain a financial gain or avoid a financial detriment by using his governmental body's time to provide outside tutoring services to students enrolled in a local private school. According to the complaint, Mr. Stratton provided math instruction during his posted work hours and while on district time to several students of the local private academy, St. Patrick's. The documentation and information gathered during the preliminary review indicates that Mr. Stratton provided tutoring services just one time, free of charge, during his lunch hour. Thus, it appears Mr. Stratton did not avoid the financial detriment of using district accrued leave, as he used his own lunch hour to provide the math instruction to the students of St. Patrick's Academy. Further, by providing these services for free, Mr. Stratton would not have obtained any financial benefit from providing these services to the students of St. Patrick's Academy. Therefore, it appears there is no substantial objective basis in this case to believe that violations of the prohibited use of office and conflict of interest statutes may have occurred. The report that is in your meeting books recommends dismissal of the complaint.
Thank you.
Thank you.
Commissioners, any questions for Investigator Walker? Seeing none, Mr. Stratton, now's your opportunity to respond. I do want to comment that the recommendation is that we move to dismiss, and I can't remember a time that we have not made a motion to dismiss. So your choice whether you want to speak or not.
My quick question, Mr. Lindsay, is in the letter addressed to me from you all, it states in either instance, this matter will no longer be confidential. And I was wondering at some point in time, if I were to apply to another job, and the question is, have you ever been under investigation? How do I answer that question? Is this an investigation or is it not an investigation depending on the outcome of today?
Executive Director Myers is going to respond to your question.
So your case is in preliminary review. The commission is deciding today whether to move it or investigation or to dismiss it. If they dismiss it, that is what will become public, is that we made the report, recommended dismissal, and the commission dismissed it.
Yeah, so if assuming we dismiss, then the answer is you were never under investigation.
Correct.
Perfect. Thank you.
Thank
That's all
you.
I have. That's all
Thank
I have
you.
for now.
Okay, thank you much. Vice Chair Fiscom, do you have a
Mr.
motion?
Chair, I hereby move that the commission find that the complaint information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. Lane Stratton has violated provisions in government ethics law, and it does not warrant further review, so that this complaint be dismissed.
Thank you, Commissioners. Any comments on the motion before us? Seeing none, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Mr. Stratton, your case has been dismissed. You'll get a letter of confirmation. And we thank you for being with us today.
Thank you all for your time.
Thank you. All right, Commissioners, we're moving on to agenda item 66. Regarding Mr. West and his attorney.
He's joining the room now.
Yeah.
He's been admitted to the room.
Great. Hello, Mr. King, are you there? Can you hear me?
Yes, I can hear you. I'm here. Thank you.
Thank you. Thank you for being with us today. We understand that you are representing Mr. West, who is not appearing. Is that correct?
That is correct, yes.
Thank you. My name is Sean Lindsay. I'm the chair of the commission. Now's the opportunity to have Mr. West's matter heard before us. And the way this will happen procedurally is we will first hear a report from Investigator McIntyre, and then you will have the opportunity to respond if you so choose. You do not have to respond. And with that said, we'll hear from Investigator McIntyre.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item number 66 is a preliminary review for John West, Commissioner, Josephine County. Received 2 complaints on this matter regarding the same set of factors. The initial complaint is that Mr. West used his official position by taking out a 1-page advertisement in a local newspaper. He used the county logo and banner and encouraged voters to vote against a measure 17-116, which is a local measure that would, among many things, it would change the number of commissioners in Josephine County from 3 to 5, and it would reduce the compensation of each commissioner. The duplicate complaint brought forth the same kind of factors, except it also stated Mr. West did not properly disclose the conflict of interest related to this advertisement. Based on the information available, it appears that anybody is actually allowed to use the Josephine County logo, not just public officials or individuals associated with the county. And ORS 244 does not prohibit an elected official from using their official title and campaign materials. So it does not appear that the advertisement in the local newspaper constituted a prohibited use of position violation. Further, reviewing measure 17-116 and the county legal confirmed this, that the passage of that measure would not actually financially impact Mr. West during his current term of office, but it would only reduce the compensation available to him if he were to run for re-election, was re-elected under the new commission structure, and that wouldn't even begin until 2027 at the absolute earliest. Because measure 17-116 is not and does not appear to have been before the Josephine County Board of Commissioners for consideration and vote by the board, Mr. West was not met with the conflict of interest required. It appears Mr. West was not met with the conflict of interest that would have required public disclosure. Further, the regulation of speech that advocates for or against a ballot measure is primarily governed by the Secretary of State and is outside of the Commission's jurisdiction. Therefore, based on the information available, it does not appear that John West violated Oregon government ethics laws, and the case should be dismissed.
Okay, thank you. Any questions for Investigator McIntyre? Seeing none, Mr. King, this is your opportunity to respond, knowing, I should note that the recommendation is to move to dismiss this, so knowing that, do you have any comments?
I do not have any comments at this time. Thank you.
Thank you. All right, commissioners. Vice Chair Fiscom, do you have a motion?
Yes, sir, Mr. Chair. I hereby move that the commission find that the complaint and information available during preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Mr. John West may have violated provisions of ORS 244.040 sub 1 and ORS 244.120 sub 2, and that no further review is warranted and that this complaint be dismissed.
Thank you. Any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Hollister,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Mr. King, thank you for being with us today. It's been dismissed and our staff will send confirming correspondence.
Thank you. Have a good
Thank
day.
you. All right, commissioners and staff, we are done with the executive session and we are hereby back into regular session. Let us know
Mr.
when.
Chair, just a quick comment. There's somebody waiting to appear before us whose matter is down the agenda. It's your call as to when to consider that individual. Mr. Chair.